follow-up post-event. At this time, I would like to turn the conference over to Mr. Kevin Stair. Please go ahead, sir.
All right. Well, thank you very much. Hi, everyone. My name is Kevin Stair, and I'm the Vice President of Sales for Lexis Litigation Software, Hosting, and Professional Services. Today, we're honored to have George Socha and Tom Gelbmann, co-founders and e-discovery pioneers of the EDRM and accuracy, speak to us today about finding an acceptable balance between e-discovery costs and risk. As we all know, this is an important topic that ties to nearly every case involving e-discovery. And judging from the number of attendees on today's call, it's very clear that there's a lot of interest in this topic. I do think it's important to note, however, that besides the thought leadership initiatives that George and Tom put forward in the e-discovery industry, they also provide consulting to law firms, government agencies, and corporations. And in particular, Tom's focus is on e-discovery consulting for project management, strategy development, and advice on technology selection. George's focus is on electronic discovery and consulting, which includes implementing and managing e-discovery strategies. He's also an expert witness on occasion related to e-discovery and other litigation matters. Similar to George and Tom, Lexis is committed to helping our clients develop and execute technology strategies designed to optimize efficiency and effectiveness throughout the litigation process. And as many of you know, as you're clients of ours, we offer a number of solutions tied to the EDRM. So we offer solutions around early data assessment and document processing, document review, deposition review and analysis, case analysis, which involves issue and fact management, and hosting. So for example, we offer a virtual litigation war room providing a collaborative environment for document review and case strategy development. All of the contact information for George, as well as Tom and LexisNexis, will be available at the end of this webinar should you be interested in contacting any one of us to talk about best practices, obtain case studies, and simply talk about our perspectives with regards to implementing a very effective and efficient approach to litigation. And with that, I'm going to turn it over to George and Tom.
Thank you.
Thank you very much, Kevin.
Well, this is George. That was Tom. Yep. We'll be interrupting each other as we go, but we hope you all will be interrupting us with questions, comments, and thoughts along the way. We'll do our best to both speak cogently and understandably and pay attention so that we can watch for your questions. One thing you will not see in this presentation, and maybe you were expecting it, will be a slide of the EDRM diagram. It's not going to be up here. If for some reason you haven't seen it and you are curious, go to edrm.net for that and a wealth of other materials. But the focus here is on finding and maintaining a balance between electronic discovery costs and risks, the two facets of electronic discovery issues that come up over and over and yet over again as we talk with people in our consulting practices, at conferences, as part of EDRM and the like. And it is very much a balancing act. This is not, diagram is not meant to suggest that the scale has to tip one way or the other, but there definitely is a scale, and there definitely is a question of how you make things balance in a way that's going to fit for what you are looking for. So how do you get there? This is a brief overview of the 4 areas we want to cover in the next hour. First, before you can achieve the goal of balancing your costs and risks, you have to do 2 critical things. One, you have to figure out what the costs are or are likely to be, and 2, you need to attempt to figure out what sort of risks you realistically are dealing with. Next, strike a balance between the 2. These things might seem self-evident, but it's perhaps surprisingly how common people rush past these steps to try to jump right into the work itself before they try to figure out how are we going to maintain these things. And then once you've tried to figure out how to strike an acceptable balance, how do you go about maintaining that balance as you move along? So with those 4 areas as the broad overview, we'll move into the first section, which is about trying to assess costs. It would be wonderful if we were able to simply say, here is the web page you go to, or here is the spreadsheet you use. Fill in the blanks, and it's taken care of. But it's way too complex for that. And even with corporations that are, if we're looking at corporations in the same industry and of similar sizes, even then, it tends to be too complicated. It's really still a question of bespoke suits rather than off-the-rack clothing. And it begins at the first step we've got here, which is to attempt to define the costs you care about. One of the things we've seen people attempt to do, and Tom, jump in at any point.
Right.
Tell me where I've gone astray.
No, you haven't yet.
One of the things we've seen people attempt to do too often is to try to be comprehensive in this initial effort at defining the costs. What is the cost? They try to cover each and every potential cost they may be dealing with. And what we find as you quickly get past the 80-20% rule or whatever you want to look at into a point where you are spending way too much time focusing on way too small a portion of the costs instead of doing, as Tom, you called it, the big bucket approach.
Right. And I think it's key to point out that, each, first of all, each matter is different, but there's similarities, and it's very important to follow what I call, standard processes. There is going to be a start of the matter. There is going to be things that you are going to want to get your arms around, whether it's, preservation, whether it's whole collection, processing, etc. It's important, and what I've seen is to have those well-defined processes, whether you're in-house in corporate counsel or whether you're a law firm working on behalf of your client, following those processes so that you can have a consistent, disciplined, and standardized approach to the matter. And the reason that that's important is that the more you follow those defined processes, the better you're able to track your costs, whether in resources, whether it's time and people or tasks, services, etc., so that you can then predict or at least have some rules of thumb associated with the cost you're likely to incur.
One of the things that happens here, though, is that people chase after the most recent bright, shiny object dangled in front of their eyes. Often that bright, shiny object is the promise by someone that we've got the Staples big, red, easy button. And we'll punch that button or you punch that button and it will take care of all of this for you. What we've seen actually be the case is very different. And one way to start at trying to approach this, beginning with defining the costs, is that chances are you already have a track record. Even if you haven't had to deal with electronic discovery issues before, unless you are a brand new company or a brand new governmental body, chances are you've dealt with disputes of some sort in the past. You've gone through discovery exercises of some sort in the past, perhaps formal, perhaps informal, and chances are somewhere you've got some information about that you can look to. You can, if you are fortunate, from that begin to start looking at the big buckets. Where have we spent the money? If we spent money on discovery, electronic discovery or otherwise in the past, did that money go largely to finding the information we were going to work with? Was it money spent on gathering that information together so we could do something further with it? Was it spent on putting that information in a form that lets us do something more usable with it? Was it money spent on reviewing that information in the litigation context to figure out whether it's relevant or potentially relevant or whatever standard you need to use? Basically, is it stuff you need to give to somebody else? And is it privileged or protected in some fashion? Basically, is it stuff you're not supposed to give to someone even though they want it and they're asking for it? And then how much do you spend or have you spent actually working with that information to figure out what it tells you about the dispute you're dealing with? How much did you spend getting it to somebody else, and what, if anything, did you spend to make it more easily presented to someone? Again, it sounds like obvious stuff, but it doesn't always happen. I was brought into a company a couple of years ago to help them assess their situation. They hadn't had to deal with much electronic discovery up to that point, but they were hearing that this was coming and that they needed to get control of things, especially control of email. And if they didn't, it was going to cost them a lot of money. We had them step back a few steps and take a look at this first part, which was, what cost do you think you actually care about? How do you know you care about them? Well, look at what you've actually paid in the past. And what they found was that the bulk of the time and money that had gone into their discovery efforts in the past had not gone into dealing with email or paper memoranda or the like. Instead, it had been money spent to go into their databases, their manufacturing databases, their supply chain databases, their sales databases, pull information out of there and get that ready. That's where their cost had been. And so from there, they were able to say, okay, what are the processes we think we're going to have to go through in the future? How are we going to go about those? What are those likely to cost us based on our past experience? So that's part of why I say that there's no easy roadmap for this.
Right.
It's very much a question of looking at where you have been to try to figure out where you might need to go.
Right. And I'll also introduce the term that's been bandied about a lot in the industry, and that's the early case assessment. And George and I wrote about this a while ago regarding early case assessment, which really has nothing to do with electronic discovery. What it is taking a look at the case at the outset in terms of what's the case worth, what are you likely to encounter. That can start to clue you in on what sort of costs you may be willing to put forth, those costs that you care about, based on the risk. What's the case worth? What is the risk of losing? What is the or an adverse result? What's the risk of settling, or what's the cost of settling? Those sorts of early decisions need to be addressed before you get too far along the line and start to spend some money. And I know that's a term, that early case assessment, that George, if you've heard George out on the lecture circuit, he talks about quite a bit.
Well, and that, we'll jump into that as a side note here.
Sure.
Because I can't resist. There is what I think of as early case assessment as described by and defined by any number of in-house attorneys I've talked with. And then there is what is being marketed in the electronic discovery arena, really I think of as early data assessment.
Exactly.
Early case assessment, it's things such as, okay, we've got a complaint on the defense side. We just received a complaint. Who are these people? Have they sued us before? If they've sued us before, how have they behaved? Do we know that in 47 days they are going to, and we are going to settle this case for 27% of what they're demanding right now? That might sound ridiculous. I had clients who were just like that. Is there insurance coverage? If so, how much excess coverage? Under what circumstances does that come into play? Is this something we can handle internally? Do we need outside counsel? If we want outside counsel, is it outside counsel with an average hourly rate of, say, $150 an hour or an average hourly rate of $350? And all those considerations. And they go on and they go on, and by and large, they have very little to do with the discovery data. Early data assessment is looking at the information available to you early on, especially because of this context, the electronically stored information, looking at that information early on and asking, and what does that tell me about what I am dealing with? What does it tell me about the dispute? What does it tell me about what actions I need to take, what preservation efforts I should be pursuing, and on and on. But that's a focus on the data. And that's where virtually all of the offerings in the e-discovery space focus. So when people say early case assessment, almost always they mean what I think of as early data assessment. Now, down off my soapbox, away from that digression, to the bottom 2 points on this slide, which is wherever you think the cost might likely be, however you define processes and whatever you do to follow them, unless you are measuring what you're actually doing and then figuring out ways to evaluate those measurements in a meaningful fashion, you're missing an enormous opportunity. You are akin to that client that I mentioned earlier, where you think that the bulk of your efforts should be focused on area X, but you think that only because you have a unexplored view of things, you have essentially taken it on faith that that's the area that matters and is going to matter. If you start taking measurements and you look at those measurements, at that point you can begin to learn more about what you're doing. Now, all of this then becomes a very iterative process. You can't take measurements and use them until you've had the opportunity to take action. So that if you're on your first pass through of all of this, of course, you don't have the measurements to turn to. But each additional matter or each additional exercise, the more data you have to look at from the past about what you've done, how you've done it, how much it's cost you, the better informed you can be as to what you want to do moving forward. It was with this in mind that in 2006 we launched the EDRM Metrics Project. The fundamental goal there being to promote efforts at measuring what you do so that you can then look at the measurements and have a better ability to project into the future what you ought to be doing, a better ability to put together a budget, match your progress against that budget, compare how you're doing in this matter against how you've done in similar matters in the past, all of which then give you a better ability to project where you're likely to be moving forward. Anything to add to that, Tom?
Yeah, well, I'd like to add to that with the EDRM metrics project. One of the things that we just announced this year at Legal Tech is that we're working on gathering a fairly large amount of information regarding matters through the EDRM metrics database, where the goal of that effort is to gather the statistics, whether it's collection, processing, et cetera, its time, its cost, its volumes, all anonymous, can't be traced back. But the purpose of this is to give clients, corporations, law firms, a place to go to get a handle of what sorts of volumes and costs are typically experienced. And so you can start, if you've never been through this before, at least you have a starting point, a starting reference. to deal with, and then apply that to within your own project. And even if you're brand new, it's your first litigation, you can follow some standard project management procedures so that you are tracking as you go along, seeing if you're on track, if you're spending more, doing more than you anticipated, understanding why, so that you can then throttle it back or go forward depending on what your experience is. That's all part of that evaluation process.
Here are a couple of very specific, concrete suggestions as to what you might want to consider doing. First, since I think the early 90s, early to mid-90s, there have been standard code sets that a limited number of corporate clients have mandated their outside counsel to use, and a limited, even smaller number of law firms have decided of their own initiative to use. One of those code sets is the litigation code set. These code sets are called the UTBMS code sets, Uniform Task-Based Management System. And I believe if you go to utbms.org, that will get you there. If you can't find it there, go to the metrics section on the EDRM site, and there are links from there to the UTBMS codes. Now, when the UTBMS codes were initially formulated, electronic discovery was not exactly front and center in people's minds. And as a result, those initial codes had nothing in them specific to electronic discovery. If you wanted to track electronic discovery, there was really only one code you could use, and there were other things that you folded into that, so it wasn't especially helpful. This last year, the group that manages those codes updated them, and one of the updates was to include a set of codes specifically for electronic discovery. These codes are a streamlined version of the ones we put together in our metrics project, but they are standard, so that if I measure using those codes, Tom measures using those codes, a provider measures, a law firm measures, the results can be compared and contrasted in a at least somewhat meaningful fashion, as opposed to me having my code set, Tom having his code set, someone else having theirs, where you can't really do anything. So take a look at those codes, see if those are useful for you. If you are using a system that allows you to track codes, chances are that if it's being delivered by a third party, if you don't already have it now, there's an update available to you with the updated code set so that you can fold those into your environment. Second thing is that to the extent you are working with service providers or using electronic discovery platforms, many providers have the ability to track what they are doing. They don't all use these code sets, but they use something. And they can report to you what they have done, how much time it's taken, how much it's cost, not just in its entirety, but broken up by tasks. Similarly, some of the software programs offer the ability for you to track what's being done in a more granular fashion. So getting measurements from providers you use, if you are in-house, getting measurements from the law firms you use, comparing and contrasting these, using the UTBMS codes if those are available, using other tools if those are available, can help a lot. If those approaches don't make sense, or you want to start in a smaller way, you can do something as simple as the following. Create your own code set with, say, 9 codes in it, or really narrow it down to 7 codes. Take the EDRM diagram, which we're not showing you. Start with the first code as identification, continue through the diagram with the last code as production. and try to track costs just in those large buckets. That at least gives you a starting point. And from there you can move on. But from here we probably should move on to the next part, which is assessing risk. Because cost alone is not everything. You need to look at risk as well. And we've broken up or divided the risk issues, if you will, into two separate groupings here. One is figuring out what risks you actually may need to address or contend with, and the other is figuring out what to do in connection with those risks. Some of this will sound like you just heard all of this from us already because you did. Just as with costs, you need to look at the past if you can and learn from the past to figure out what to do with the future, so too with risks. If this is not your first time through all of this, even if it hasn't been in an electronic discovery context, but a more traditional paper discovery context, you probably already have some sense of what risks you've been facing. Risks fall into a couple of groups here. One of the most common risks in the electronic discovery arena is associated with the failure to adequately preserve electronically stored information that later on you need to use. And while courts and the various legal requirements out there do not mandate that we be perfect in this, we are expected to do something that passes a reasonableness standard, which of course is only applied after the fact. So you're always guessing as to whether what you're doing is good enough. But one of the biggest risks is in not doing an adequate job of preservation. The second big risk here is tied to costs, and it's a failure to adequately manage the processes that are being run, and in particular to control what's happening with costs. You do not want to be in a situation in the first group where you are trying to explain to a judge who has run out of patience with you that it really was okay for you not to have sent out a preservation notice, and it really was okay for you not to have taken steps to preserve fill-in-the-blank information. It might be email messages, might be a portion of a hard drive, might be part of a file share for this one or these two or three key people. You don't want to be in that situation. Similarly, you don't want to be in a situation where I pulled into a matter several years ago, maybe about 5 years ago. It wasn't a lawsuit. Rather, it was, I think it was a second request. I forget exactly right now. But a company needed to have a lot of data looked at and very quickly. Their outside counsel, their trusted go-to outside counsel, said, look, we don't have time to compare and contrast. Here's the provider we think you should use. Go with them. We can't give you a specific number, but we can give you a range based on what they tell us, based upon what we've told them. On the low end, $135,000. On the high end, $815,000 to do this work. The work was begun. The work was finished in about, I forget, maybe a 3-week period. The law firm involved and the provider involved and the client involved, none of them managed the cost side of things, leaving all three of them exposed to a huge risk of cost overrun, which is exactly what happened. The scope changed. Client said, we got this stuff now. The folks at the law firm turned to the provider and said, you've got to do this work now. How long will it take? No one asked how much it will cost. The provider did the work. The provider sent the bills. The folks at the law firm were too busy doing the work to focus on the bills, let them pile up, and once everything was done, sent 3 weeks worth of invoices on to the client. Low end of the range, $135,000, high end, $815,000. The bill, $2.7 million. the client did not pay $2.7 million or anything approaching it. I don't know what ultimately was paid, but I'm pretty sure it was not more than the high end of the original estimate, and I don't know how the additional amounts were divided by the law firm and the provider, but it was pretty clear that neither one of them was happy with this outcome. Had people been watching what was going on? Had they been monitoring costs, comparing budget against actual against budgeted? They probably could have gotten themselves through this without this type of problem at all, and everyone would have been happier.
And that's George's horror story there is a good example of why I talked earlier about following defined processes, basic project management principles, which can help you manage the risk. One of the things that I've learned over a couple decades of project management is that no project goes as you anticipated. There are always problems. The key thing is, how do you deal with those problems? How do you spot those problems once you start going off the track, and how do you get back on track? And so that, again, it starts with that disciplined, defined process that you follow, and you assess the risk, you monitor, you get feedback as you go along. The example that George described, that didn't happen. I mean, you can't go millions of dollars over budget if you are tracking and staying on task and monitoring what is happening. And that's one, excellent way. Basic project management to manage the risk, assess the risk, and deal with the risk.
Now, we've been going for about a half an hour, and either Tom and I are doing an exceptionally good or exceptionally poor job with this presentation, or I'm completely missing stuff because I haven't seen any comments, questions, or anything. So please don't hold to the end, because we all know what happens when that happens. If you hold your comments and questions to the end, there won't be any time to address them, because we'll just keep talking until we get there. So if you do have anything you want to ask us about, challenge us on, any direction you want to steer us to, make use of that chat function. We talked about the first chunk of notes here. Look to the past, learn from the past, apply to the future. But there's the second part, which is mapping risks, assigning values, creating scenarios, and evaluating what you've got. All four of these bullet points in the lower part are as much art, more art than craft, and more craft than science. The more you do it, the better you will get at it. But if you don't try to do it, you're not going to get anywhere with it. There aren't any tools that are the one and only set of tools you can use that will get you there. There are many different options. You can use Excel. You can look to other options out there to see what you can find to help you. But however you map the risks, whether you start building an Excel spreadsheet, whether you turn to your whiteboard and start writing things there, whether you pull out a cocktail napkin and try to write things down there, you want to start mapping things out so that you have a set of likely risks to turn to. I find that for myself, and I see for others as well, that if you've got that list made and you have that to refer to, you're far more likely to protect yourself against the downsides than if you try to keep it all in your head, or, of course, if you haven't thought it through in the first place. Similarly, there's the question of assigning values to risk. All risk is not equal. Are you in a situation where the failure to preserve risk is more significant to you than the cost running out of control risk, or is there a third risk that matters more to you? When you assign values, I've seen folks use a couple of different approaches. With varying degrees of success, no one approach inherently better than the other. One way of doing it is to focus on absolute risks. Create for yourself a scale. Might be a simple scale, 1 to 3, a more nuanced scale, 1 to 5, or a more complicated scale, say 1 to 10, or even 1 to 100. And for each risk item, you attempt to place it somewhere on that scale. But it's an absolute point on the scale. And then you can compare and contrast what you have, and you start to see things adjust as time goes along, as you learn more, but you've got that risk profile to look at with the risks identified and then values assigned to them.
Right, the values and, what's the worst, and that gets into the best, worst, and average. What is the worst?
Well, one more thing before you jump into that, Tom.
Sure.
The other way, instead of doing absolute risks, is assign relative risks. And one way of approaching that is you may have 5 risk items you're looking at. Start with risk item 1 and risk item 2 and say, okay, where is the risk greater? It's greater on risk 1. Okay, now let's take 1 and 3. Where is the risk greater? It's greater on 1 than 3. Okay, now let's compare 2 and 3. Where is the risk greater? And you put them in a hierarchy based on their relative risks. And I've seen people do that quite effectively. I've seen people use the combination as well.
Sure.
Now, Tom, scenarios.
Sure. Well, and then also factoring in there, what is the likelihood? What is the likelihood of that risk, actually coming to light? And that's where we get into the various scenarios. What's the for a particular risk? What's the best or the best outcome, the worst outcome, and what's the more average or realistic outcome for a particular scenario? And if you're following if you're following your process, your procedures, looking at that, you know where the weak links are, where the weak spots are, where the risks are, and you can come up with those scenarios that can then inform you as far as what sorts of actions you might want to take to protect yourself, to bring, to avoid the worst outcome, and work towards that best outcome.
Okay, well, we do have a question, so I will interrupt with this. Read the question, and then we'll see how far we can go in responding to it. The question being, what are your suggestions for assessing costs and risks in a decentralized company with distinct operational areas and business structures, which lead to distinct litigation profiles in terms of volume and exposure? So a decentralized company as opposed to a centralized one. And of course, the first response is a recognition that it can be much more complicated in that environment. Part of where I think you need to go, and this jumps into the next session, or the next slide we have, which I'll get to in a little bit, but I think part of where we need to go is that once you are dealing with a decentralized company, you are dealing with, in many ways, separate entities. So that each entity, there is going to be a person or a group of people that you're going to need to deal with. There's no one centralized person with a centralized function and control over all of this. You can try to get those people together in a room if that's appropriate for your circumstances, or get them together virtually. But they need to, they'll work most effectively if they have a common plan to work off of and are able to slot their pieces in so that you have the same sort of compare and contrast across divisions. Capability that I was talking about with the ability to compare and contrast across law firms if you're a corporate legal department, service providers if you're one law firm using multiple service providers. So if you can get a common template and a common understanding about where you're trying to go, and then get people to fill in and work with that common template, that can help. In some situations where you're dealing with a decentralized company, you also have decentralized legal units, so that you have a corporate counsel who are attached to that unit as opposed to a centralized corporate legal function, or you've got a combination of both, centralized and decentralized corporate legal functions. If you've got those corporate legal folks dispersed, you probably want to make sure you've got them involved as well. Similarly, if you've got dispersed IT folks, you want to get them involved.
Right. Another aspect of the decentralized environment too is that, as George mentioned earlier, they are separate entities, and so it's really a grassroots type of approach. Is that the individual entities can start applying some of these principles, and to the extent they can demonstrate success, they can share that experience, those experiences, those processes, those approaches with their siblings, their organizational siblings, and say, hey, it worked here. And so from a grassroots approach, you can get to the more of a standard across the entire entity.
Another question raised here. We'll try to step through these and make sure we save time for that. That next slide, which will help a little bit at least. But it is any advice easily overlooked for those of us on the plaintiff's side. Part of this is that I don't think we necessarily help ourselves by thinking of electronic discovery as a plaintiff's versus the defendant's issue. It's more a question of who's requesting and who's responding. Because by and large, both sides have electronically stored information. Corporations do, governments do, but individuals do as well. And an individual's failure to handle data appropriately from a responding perspective can be every bit as problematic as a corporation's or government's. Similarly, chances are, whether you are the defendant or the plaintiff, you are looking to get data from the other side. So if you will, everyone's a plaintiff and everyone's a defendant in all of these. So on the one hand, you want to be thinking about what is it that I need to get, and the other, what is it I need to hand over. We've been talking primarily about the responding side of these, but on the requesting side, one of the big risks is that you ask for too much. And asking for too much isn't a risk. Getting too much can be a risk, because at your own request, you can have that semi-truck dumping way too much stuff on your way too small backyard, and then you can't figure out what you got and what you want to do with it. So one of the challenges is in making sure you are focusing your demands on the things you really care about. Another request, a risk, is that you ask for too much, and you end up finding that you need to pay for part of the process of getting that too much to you. Now, you not only have data you don't want and don't care about, but you have to pay for it as well. You don't have to pay for all of it probably, but you might have to pay for a big chunk of it. So those are I think, the areas of biggest risk from the requesting side. I don't know, Tom, anything to add on that point?
Not at that point.
Okay,
next one. Into the next slide.
What's the most important thing a new attorney or paralegal should know about e-discovery? And this in particular, firms that aren't technologically advanced and where that person becomes the go-to technical person in the office. Probably the single most important thing to know is that it's okay to roll up your sleeves and experiment with things. You can take a copy of some data and test it, play with it, try it out with different tools. See if you can get evaluate copies of software programs from people. See if you can get providers to run a test for you of things. Until you have your sleeves rolled up and you have your arms in the thick of this, you're really not going to understand well enough what you're dealing with. So more than anything else, roll up those sleeves and try things out. Second, try to make your mistakes small rather than big. So don't try to do everything all at once, especially if you haven't done it before. Try to do it as a little piece first and then expand from there. Third, find help. Might be someone else in the office, might be outside of the office. Many service and software providers are glad to offer you assistance with the hope that you will be so impressed by them that you will come back time and time again after that. And make use of those resources. Go to things such as the EDRM site for a focus on what to do on the practical end of things. Go to things such as the Sedona Conferences site if you are more concerned about learning about the legal sides of all of this. There are any number of places where you can find case law focusing on electronic discovery as well. So
and the only thing I got to add to that is don't be shy. Ask questions. There are no dumb questions. The only dumb question is the unasked one. So there's lots of resources out there, as George pointed out. But if you really don't know about something, you're questioning yourself, ask the question.
Next one. And by the way, in covering these questions, we are by and large also addressing what we've got on the remaining slides, just so you know. Next one. When does the client saying, we can do that in-house, start to present risks that everyone needs to buy off on? I'd like to turn that around. When does the law firm saying, we can handle that for you, start to present risks that everyone needs to buy off on? It's not really a question of whether this should be done by the client or by the law firm or by a service provider. You want to make sure that whoever is handling this is well positioned to do so. There are clients who are much better placed than any other outside counsel to take charge of and run these things, and I've seen ones where they have not only done it well, but they've done it on a much smaller budget than they would otherwise have paid. Similarly, there are clients who have no business at all trying to deal with electronic discovery directly themselves and have to depend and ought to depend upon someone on the outside. The same can be said of law firms. There are those who have exceptionally well-experienced, talented people who can go a long way toward guiding you through this process. And then there are those with folks who think that all they need is the old razzle-dazzle to get through it, and those are the most dangerous people of all. And by the way, you will find both of these in the same law firm often. So you've got to look at that. One of the big dangers is that you can find providers who are very good at what they're doing and providers who really oughtn't to be in the market at all. And you need to take a look at them and try to assess them as well if you're going to be relying upon and depending upon them to make sure that they're not going to be the ones that get you into trouble. Question here about can you explain code sets more? The basic idea is that we'll create a really simple code set like what I referred to before, 7 codes. 1, identification, 2, preservation, 3, collection, and so on. You spend an hour of time trying to identify what data you're going to need to put a hold on. When you record your time, you assign that code, ED1, to that time. Then you spend 30 minutes actually preserving data. You assign that code, ED2, to that. You keep track of all of that. Then you can look back later and say, okay, we spent 300 hours doing activity in this area. We spent 200 hours doing activity in this area in this case, but it was the reverse in that case. Then you might try to dig into greater details into the narrative, for example, to figure out what's there. If you go to the UTBMS site, and I believe that's utbms.org, You can see the code sets there, and if I recall correctly, there are descriptions as well. You can get at similar materials if you go to edrm.net and follow the links to the metrics section. Let's see, what else do we have?
Any other questions coming in?
I think that's it for what I see here. So let's jump, before we run out of time, to our next slide, achieving the goal, and 5 things to keep in mind. 1, you got to figure out who's going to decide who decides. You can't be all chiefs. Someone's got to be a chief. Someone's got to make the call. And is it someone in legal or someone in IT, or do you have joint leads to someone like this? People most frequently involved in looking at costs and risks with respect to electronic discovery are found generally in the following areas within a corporation: within the legal department, within the IT operations, perhaps in information security, perhaps in records management, records retention, information governance, if the organization has a group like that, human resources. Then you sooner or later will need to pull in the people who are in charge of the key business functions. By key, I mean the ones implicated by whatever dispute you are dealing with. It can spread from there. In a law firm, in terms of who decides, it's a clearer hierarchy there, starting with a relationship partner and the partner who's managing the matter, junior partners, senior associates. There might be a junior partner or a senior associate who's really in charge of the day-to-day actions. Some law firms have dedicated electronic discovery or litigation support personnel. If your firm has those people, please make use of them. I can't tell you how many times I have been pulled into lawsuits as an expert witness where I talk with the lawyers on the case who say, oh yeah, those folks, we know we have them, but we don't use them. And yet I know who they have, and I know how much benefit they would have gotten out of using those people, and how much that probably hurt me, because if they'd made good use of those people, they probably never would have needed me at all anyway. Agree on the decision criteria. Whatever criteria you're putting on, you need to come to a consensus about what matters, what's important, what risks you care about the most, what costs you're most concerned about. And set those levels. Learn to say no, and this is the hardest piece of it. It's a cost-risk balancing. Too often, especially in law firms, the focus is on cost and not on risk. And you need to balance the two.
Right. And I want to point out that even though this is the last slide, these are some things that probably should be addressed first. Who decides?
The very last slide, which I'll put up just for your entertainment, is that once you try to strike an acceptable balance, you need to maintain that balance. And for all of you who've been on a teeter-totter, all of you who've tried to balance a board over a log, you know that keeping a balance is not an easy thing, and it's not an easy thing here as well. Litigation, project management and litigation, that's part of what we're talking about here, is very different from project management in, say, a manufacturing process. Because there, generally speaking, you and your suppliers, for example, are trying to work together. Litigation, by definition, you're up against someone who's trying to make sure you don't get what you want, who's trying to throw you off, who's trying to confuse you, trying to distract you, trying to drive up your costs and drive up your risks simultaneously to get you to get where they want to be. So keeping that balance is a major challenge. Let's see if we have any other questions that have come in here, because I know we are running up to the end of our hour. I don't think so. Tom, any last thoughts to throw in?
No, my last thoughts were that second last slide. I can't emphasize that enough. Is that it starts with good planning, and I talked about project management and defined processes throughout this process here or webinar. These are things you need to get out of the way and settled at the beginning. Who decides? Is it the partner? Is it the law firm? Is it general counsel? As George said, the IT, whoever. And then what are you going to base your decisions on? And some of these are going to be very big decisions. Some of these are going to be medium-sized decisions. But it really helps to get that out and well-defined at the start. Then, when issues come along, problems come along, you're in position to apply the criteria, and whoever's responsible makes that decision, and then you can move on. When
Great.
a problem comes up, that's the last time you want to. That's the last place you want to be, is deciding who decides.
Well, I would like to thank all of you for staying with us. Tom, thank you, of course, and the folks at LexisNexis, thank you very much for hosting this webinar.
Very much, yeah.
Any last comments? Tammy?
Well, Tom and George, both, thank you both very much for agreeing to host this webinar for us. It's definitely an honor. And I want to remind everyone that George and Tom also provide consulting to law firms, government agencies, and corporations. They are the co-founders and e-discovery pioneers of the EDRM, so they're the experts in this field. I also want to remind you regarding your CLE, we will be sending you a notification within 15 business days of this webinar. I hope you have found it useful, and we appreciate your time today. Thank you.
Thank you.
Thank you. That does conclude today's presentation. Thank you for your participation.